Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And hello, friends. This is Ben from A Lawyer's Guide to the Galaxy podcast with a brief scheduling update, and then we'll get you into some new content. As you've probably noticed, we've had no new content in August. We are very sorry for that. Kirk and I have just not been able to get our schedules coordinated, but I am pleased to announce that we have a recording time scheduled soon, and we have lots of new content coming your way. There's a lot going on right now in the law. I don't want to spoil it, but I am going to sprinkle in some rewind episodes here that may give you a hint about one of our upcoming topics. But in the meantime, as of right now, Kirk and I have 3 new episodes planned, and we're going to cover something we've talked about a lot on the podcast, but never actually devoted an entire episode to, and that is collectible card games. There's some wacky stuff going on in the world of Magic the Gathering specifically, but the legal issues we're going to talk about really apply to any collectible card game, and we're really excited to dig into that. I also have 4 Edamame episodes in my email that Kirk has recorded. So I've made the executive decision to release those, but not in our normal numbering scheme. I'm going to preserve that for our more traditional episodes, just for logistical reasons, so I can just kind of release those Edamame episodes now and not worry about whether it's going to get screwed up with the regular numbering system. But they will be featured at the top of the website as the newest episode, so if you're looking for our most recent one, you'll find it there. Those will be coming out on a staggered schedule over the next several weeks. Kirk's 4 episodes, plus, like I said, a rewind episode or 2. And then we have our 3 new traditional format episodes, the first of which should be out within the next week or 2. So this episode is the first of Kirk's 4 Edamame episodes. So please enjoy that, and just know that there's a lot more content coming your way soon. Thanks.
Hello, we're going to do another Edamame episode here. This one is going to be a little different. I'm going to talk about some science fiction. This is actually discussing the way patents oftentimes get treated in popular media. I know we've touched on this before, but I'm talking about it in particular, and I want to talk about it in conjunction with the season premiere of Season 3 of Roswell, New Mexico. This was actually a topic that came to me. It was brought to me by one of the Twitter followers that I have, TP Tigger. So thank you for this idea as to what it was. But she is a patent agent herself, and had commented about sort of the interesting way that it was presented in conjunction with this particular season premiere, and it was intrigued me enough that I looked into the episode and wanted to talk generally about it. So we have talked before about it, about the idea of how are patents treated in entertainment media, and how oftentimes it's really talked about wrong. I know in one of the early season episodes, we talked about, and it's a movie I love to harp on, The Spanish Prisoner, which is an utterly brilliant movie if you haven't seen it. It's a wonderful movie to see. Very good suspense movie. The issue with it is that the whole thing they're trying to deal with in conjunction with it is a stolen patent application. And in many respects, what they're after, and the MacGuffin, I guess, for the movie as to what it is truly a MacGuffin. In that movie, there is no point behind it. But this one, I'm going to talk about it in conjunction with this season premiere. It's called Hands, of Roswell, New Mexico. To give you the premise behind this, just, Roswell, New Mexico is not a show I watch. This was definitely something, again, this issue intrigued me, so I decided to watch this particular episode of the show. It's the only episode of the show I've seen, and I have not seen its precursor, Roswell, either. So I have to say I know very little about the basic premise of the show, but, being a season premiere, it definitely was, I think, pretty clear as to what the basic premise of the show was and what was going on. For those of you who watch, sorry if I misrepresent anything here as to what I got from it. But for those of you who don't, the basic premise I'll give you, it's mostly set in Roswell, New Mexico. A group of individuals who apparently are aliens from, I think, a variety of different locations. They all have some form of superpowers related to what they do, and the survivors are displayed a little bit in conjunction with the show. It's what we have. It appears that they're fairly specific, and they're clearly trying to understand what's going on, who they are. There's some indications that sometimes their superpowers are dangerous, and that is a sort of core element of this. Is that one of the characters is dying from visions that she has because of her superpowers, and that it has to do with sort of seeing the future in a predictive life type of thing. The key element of what this relates to is the season episode does sort of end. Clearly, the prior season ended on a cliffhanger, which is immediately resolved, and then they jump to a 1 year later sort of video montage. One of the characters at this point in time now works for what you presume is some form of genetics lab, genetics company in California. And they are developing a cure for, the neurophysiological diseases. They mention Alzheimer's in conjunction with it. I get the impression this has something to do with the various alien superpowers here. And it's, in my mind, and again, it was, unfortunately, I can't watch that particular scene again easily, was generally portrayed as wonder drug for various neurological diseases. And that was, is what it's portrayed as. The element around the patent and the intellectual property is associated with this. And I'm going to leave behind, and I'm not going to talk about the scene that introduces this and some of sort of the interesting scene in conjunction with gene splicing and the science that's discussed behind that, simply to say that is sort of nothing to do with gene splicing. But I want to talk about the portrayal of the patent. And the patent is talked about twice. The first instance it's talked about, you find out that they have obviously invented this important drug. It's ready to go. It's going to save lives. It introduces a neurophysiological thing, but there's discussions of a need to get past the FDA and to deal with FDA approval, which is an expensive process, an extremely expensive process in most cases, and usually takes some time. And there's discussion of the idea that that's being shortcut. You get the boss comes in and sort of tells us it's being shortcut. How is it that they're doing it? And they're doing it very quickly because it's being shortcut as an anti-wrinkle cream. Or anti-wrinkle treatment, as opposed to something associated with this, which you find out in the statement is an appropriate use of it, but obviously not the intended use of it. So at that point in time, it's mentioned that, there's a problem with introducing it that way because it's not going to get out there to help people, because the company's going to have a 10-year exclusive in the course of getting this FDA approval with it, and that's going to, sort of chew up their patent rights, and cause problems for the patent rights. Later on in the course of the show, what you discover in conjunction with this is that they both get sort of warnings on their phone that the patent has been leaked. You get the sort of, slightly strained scene, I think, as to the two coworkers, again, who are collaborators. Liz is the sort of key one here. The other one, I'm afraid, I don't know the name, again, not being particularly good at the characters. But has found out, that this thing gets leaked. You find out that Liz is the one who leaked it, or, hypothetically could be the one who leaked it. And the sort of discussion of, what is that's going to impact their careers. They could both be fired over it. This could be a problem because they can't continue to sort of do the life-saving research. An element associated with this had to do with getting further grant money in order to continue to do their research. And that grant money is important. Basically, what comes out of it is because it's leaked, they need to go in, they need to break into their lab, they need to do something in the order to essentially stop the leak, to stop the sort of problems that are going on in conjunction with this patent being leaked. And that's, what they're going to do is they're going to go in and they're going to fix this problem. So that's the two things that are sort of the premise of this. The reason I like talking about this is because when we think about it as a whole, the idea that, hey, these people have developed what's effectively a life-saving cure or, dramatically life-altering cure, is a very logical premise for a scientific show. That we have, hey, they've developed this and getting it out there is an issue. The basic premise of how do we get it past the FDA is a very logical one. I mean, the FDA regularly does not approve life-saving treatments. And I mean, there's been a lot of discussion recently in the press about the role of the FDA. That has been both around the Alzheimer's drugs, and the question as to whether or not they should have essentially given approval to an Alzheimer's drug, which, may have questionable efficacy. And on the other side, the approval of the COVID-19 vaccines, both provisionally and full approval, which at the time I'm recording this, full approval has just been granted to the Pfizer vaccine. It has not yet been granted to the Moderna, but that is expected to come soon. And so, you have sort of the competing interests of, what should they grant, what should they not grant, what is the role of the FDA. Obviously, with that being a popular question right now in the world, and a debate sort of, being had in the United States in particular, what is sort of the role of pharmaceutical regulation, the idea of this drug being held up by the FDA and that needing to make compromises is a very reasonable premise. The interesting thing about it is I see it as there are a number of sort of major mistakes that they make in discussing patent law, some of which I think are more forgivable than others. And unfortunately, a lot of them flow from each other, but I think they really illustrate issues in conjunction with patent law. So the first thing is they repeatedly refer to this as being their patent. And the first thing you really bump into with it is there's two potential issues here. One, are they referring to it as, is it an actual patent? Is it a granted patent, something that's been patented? And the issue with it is if it's something that's been patented, a lot of their concern about it is misplaced. So the example I get into with this is something which is patented. If I go out and I get a patent on my life-saving disease treatment, once it's patented, the patent is granted, how to make that treatment is public information. In order to get a patent, and we've talked about this in the show before, you have to file the application. The application's reviewed, and at least at the point of grant, and oftentimes beforehand, that application is made public. And again, the patent is always public. So patents are public documents. If you want to go to the United States Patent and Trademark Office, uspto.gov, and do make sure it's .gov.com will get you a law firm, or at least used to. So if you go to uspto.gov, you can search all the patents that have ever been granted by the United States. There are other search engines in most parts of the world. The Japanese Patent Office has one. You can even search the Japanese Patent Office in English reasonably well. It's a lot easier to search it in Japanese. But there's also ones for international patent applications. There are ones for European patent applications. There are Canadian patent applications and patents that you can search. So the key about it is once a patent is granted and you have a patent, and again, I'm focusing on that word in particular here because that word has legal meaning. That the document which is the patent is secret, is no longer secret. The file that you go through to get to that patent is no longer secret. At this point in time, anybody can review everything that you filed with the patent office to determine how to make it. You're expressly expected to. It's a key element of the United States patent law that basically you have to grant public access to the document. The statement is that you get a term of monopoly in exchange for public disclosure. That's the play off of it. The reason why that matters and the purpose behind it is that the public disclosure will encourage further innovation. If I know how something works, I can further innovate from that. The stereotypical, favorite phrase, if I have seen further, it is because I stood upon the shoulders of giants. And again, I can never remember which, I believe it's physicist that said that. I think it was somebody associated with the Manhattan Project, but it is a famous quote. And one of the things that you have, from it, the idea of continuing that scientific revolution from what's already happened requires it to be public. So that's our first premise. In all cases in the Roswell, they refer to it as a patent. So if it is a patent, the concern that this has been leaked is nonsense. And that's sort of the initial problem. You can't leak a patent. A patent is a public document to begin with. In fact, a patent is such a public document that you cannot prohibit copying of the patent document itself. Patent documents are not covered by copyright. We've mentioned that actually on this show before. You can go and physically make a copy of a patent from the United States Patent and Trademark Office. You can distribute those copies, and there is nothing the person who wrote it as an author, again, a patent attorney commonly like me, can do about it. It is not covered by copyright. There's certain ways where you can place certain portions of a patent application, such as if you include computer code under a limited copyright where the person can still make a copy of the patent document but cannot actually use the code or make a copy of it outside of the patent document. But the patent document itself is public. So the idea of leaking a patent is literal nonsense. It's impossible. And that's the reason that I want to focus on this. And I think one of those things that you sort of jump out, where it jumps out at you when you're a patent attorney. And it's something, again, that's common. And I think you see commonly throughout entertainment literature is the idea of this presentation of that a patent is somehow secret, that there is somehow that the right of a patent can be lost by making it public. It's exactly the opposite. A trade secret can be lost by the act of making it public, but a patent is public, and therefore it cannot be lost. So I pick on that as sort of the first thing as to, hey, these characters are referring to it as a patent. But what they're referring to here may not necessarily really be a patent. And what they're really maybe referring to is a patent application, the idea that we filed for an application for a patent. Now, patent applications are maintained in secret. They're maintained in secret in the United States for a minimum period of 18 months, unless you choose to make it public before then, which you can do. But the first 18 months of pendency of a patent application in the United States, it is secret. If you only file for patent protection in the United States, you may maintain the patent application in secret until the patent actually grants. And that's because the requirement of publication at 18 months and making the file public at 18 months has to do with international treaty. So basically, the United States has said, hey, if you're under the international treaty, you're obligated to publish the application in 18 months. If you're not availing yourself of any right under the treaty, the United States patent law governs. The United States patent law says you may keep it private up until the point in time that it actually grants. But when the patent is granted, it is a public document. So you can be referring to the idea of a patent application being secret, which is a much more logical statement here. The issue with it is they don't say patent application, they say patent. And I harp on this one because while it's an important word, it's a very common mistake in the way people refer to it. Even patent attorneys, myself included, will occasionally say patent when we mean patent application. And it's a problematic thing because they are different and they do have legal meaning. A patent application has no rights attached to it other than certain preliminary rights related to its publication, which don't even attach until it becomes a patent. They get to jump back a date of what happened during the patent application process once it becomes a patent. But a patent application is very different from a patent, and that's a sort of key thing to keep in mind about this. As I said, though, it is a very common mistake. Inventors will commonly say my patent when they mean my patent application. And it's just because, again, you can understand the nature of the English language. It's a simple mistake. They're referring to the same thing. They're using different words, but those words do have legal meaning. And obviously the concern here is the presentation in the media is the idea of what is a patent versus a patent application. So we get that as maybe what they're actually saying here is our patent application, which could be a secret document. So you definitely could have a secret document associated, as a patent application. That secret document obviously could be leaked. The key is in a patent application, you don't know whether or not a patent is going to be granted in the end. So therefore, leaking it as a secret, if the patent wasn't granted, that could be made, the material in the patent application could be maintained as a trade secret if the patent is never made public. So that is a possibility. And for those of you who may be interested in sort of some of the nuances of patent law, that is a strategy that is sometimes used. I mean, I have myself used it. Most patent attorneys use it at some point in time, where you will purposely keep applications from becoming public, from publication, if you're only applying in the United States, until they grant, so that if they don't grant, if the patent is not granted, you maintain the trade secret right and potentially whatever's in the application, or at least maintain some confidentiality and don't tell your people your competitors how to do it. And again, that's the nature of a patent application. As part of that disclosure, you have to explain in the patent application how to do it. So the patent application would effectively need to disclose this is the drug that they are talking about, the intervention that they have, which is this neurophysiological treatment. And it would need to basically tell people how to do it to the extent that at least somebody in their position in another company could copy it. So, the patent application does have that kind of information. So we treat it as the idea of it being a patent application. Suddenly, the idea of it being leaked makes much more sense. The patent application comes out and says, hey, the patent application has been leaked. This can give our competitors a jump on it. In particular, in conjunction with FDA regulated drugs, this can be an issue because there are certain things that companies are allowed to do in sort of preparation for going to the FDA that they may not otherwise be able to do. They effectively can violate patents in certain ways in order to prepare for the FDA, because the FDA process takes time. So this is an area of patent law I don't get into a lot just because I don't work into pharmaceuticals that much, but it is a major, sort of major consideration of timing associated with the FDA and with patent rights. So we do have an issue there that, if she's talking about a patent application and not a patent, it is definitely possible that, this could be leaked, that leak could present a potential issue. And that they could lose their jobs over. Now, obviously, an employment agreement, leaking a trade secret is, without any question, under most employment agreements, grounds for termination. His concern is not unjustified. As to what you have here, that is very reasonable if we treat this as a patent application. So, with that in mind, let's just assume they really meant patent application when they said patent. At that point in time, the second piece of this, the issue associated with we have to go and prevent this leak from happening. We have to make sure that that it isn't found out that we did it, all those kind of associated issues around this as to what we need to prevent are very reasonable considerations to take in mind. This needs to be prevented. They readily could lose their jobs over this. They readily could, be terminated for cause. They readily could be liable for damages, for doing this from their employer. So, there is a legitimate risk there. The concern you get into from that is if it is a patent application, the first presentation of this, which is again the idea of saying we're going for FDA approval, we're doing it as this alternate, and that we have a 10-year license right, and that 10-year license right, the fact that it's going to be licensed exclusively 10 years as conjunction with an anti-wrinkle treatment as opposed to this treatment for neurophysiological diseases is a major issue. The reason why I present that's kind of a strange presentation for a patent application is while a patent application can be licensed and commonly is, it's highly unlikely that would be licensed for an exclusive period of 10 years. Patents run for a period of 20 years. Now, there could just be an exclusivity window in it. But again, taking the premise of the show, our scientist has worked here for about a year. That does fit the patent application, by the way. Typically, patent applications pend for 2 to 3 years before they're granted. So it does fit that she is really referring to patent application at this point in time. It's an application which has been filed. But it's interesting that a company would be able to license the technology on a pending patent application to somebody else that would sink in the money to get FDA approval. And pursue it as this way without any patent right granted, in conjunction with it, recognizing that it could readily be a couple of years before the patent right is granted from it. And again, the 10-year window of exclusivity is kind of an interesting time period to be talking about. Again, most of the time, if you were going to license a patent like this out as an exclusive window, you would typically license an exclusive window. It wouldn't be surprising for you to license it as a 20-year exclusive window, because that is the term of a patent, or license it for the term of the patent. Patent terms can be extended slightly beyond 20 years if it takes you too long to get through the patent office. So there is some stuff there, that says, okay, they would have term on it. The issue is the implication is that somehow they would lose rights. The course of the 10-year period, hey, because of this license, the whole concern for and the reason for leaking the patent application is because this is effectively going to cost them the ability to use this drug. So they're leaking it to the competitors so that the competitors can get it and use it as the neurophysiological drug. A couple problems with that. Obviously, one, at the end of the 10 years, those rights would presumably license back. They're now non-exclusive, so the original patent owner could obviously use it for any purpose. But if we can say, okay, yes, it's a period of 10 years that's being used exclusively for this purpose, it's a strange license. I guess that's the way I'd put it. If I had a drug which obviously showed promise as a potential, cure for Alzheimer's, I could very readily, if it also had the ability to be used as an anti-wrinkle cream, make a deal with somebody to say you can use it exclusively, you can market it exclusively as an anti-wrinkle cream. In exchange for getting it through the FDA on that ground. That is a very normal thing to do. But such an exclusive license would typically be restricted in scope to it being sold as an anti-wrinkle cream, not as it being sold as an Alzheimer's drug. Instead, it would be something where I could utilize it as the Alzheimer's drug. I could treat it as, again, this neurophysiological effect that I would be allowed to pursue the FDA over and do it even during your window of exclusivity. In your 10-year window of exclusivity. Again, it's not that the contract they state there is impossible. I would just say it's a little implausible. as to a ground as to how a contract like this would be created. It also has the idea of, again, the implication being we have to leak the patent in order to get the drug out and have it be out there. Doesn't really fit, again, as a patent application. That patent application would eventually become public. So while it's secret now and leaking it is an issue, it would eventually become public. The nature of the patent becoming public would then involve the competitors knowing exactly how to use it. If the concern there is, hey, it's going to chew up our patent because of the fact that, our patent doesn't stop people from using it as a neurophysiological drug, you have the same effect of the leak. If we have it in the course of we can do that. We may have this tangle to say, hey, yes, we've paid for a 10-year exclusivity in somewhere else. But, that's just the nature of the contract. So again, what I look at here is I think the major issue here is the reference to patent versus patent application, but also that the premise set up, if we look at it and say a patent application makes the latter need to prevent the leaking to occur or to sort of cover up the leaking of whatever it might be, saying it's a patent application, it does make the 10-year licensing scheme discussed earlier, which is the whole premise for leaking it in the first place, implausible from a sort of patent law point of view. We really have an issue that it would imply more of, okay, yes, they're getting an exclusive 10-year license to our patent, to our granted patent. We're granting them exclusive. They are taking that through the FDA. That is going to chew up more term because now that it's granted, we're losing patent right. It just makes it more reasonable to say that at that point in time, they probably are referring to a patent when they're referring to the potential sort of license scheme associated with it than to be referring to a patent application. The real thing with it is that this confusion could be readily gotten rid of if they simply treat the drug as a trade secret. And saying, oh, it's our trade secret, it's not been discussed. Well, now a trade secret is something which is maintained in secret, which revealing it could be an issue. And obviously, if we're going to say, hey, yes, they can use it, they can market it this way as a trade secret, we're keeping secret the fact that it is an Alzheimer's drug. And that's really, I think, the key here. Is the premise behind this, or again, and I say Alzheimer's drug because that's mentioned later on as part of the motivation for developing things like this. It's a neurophysiological drug. It's got secondary effects. And again, I'm not sure they specifically say what it's for. I think that's one of those where I think it's a treatment associated with the alien effects that are behind this. And obviously, people who are fans of the show, TV Ticker included, if you listen to this episode, you can feel free to point out, sort of those issues there as to, my presentation of what exactly this drug is. But what we look at is the fact the drug definitely has two effects, one of which is this cosmetic effect, which is what's being used to get through the FDA quickly. The second one of which being an actual major sort of life-saving, potential effect beyond that. We could look at it and say, hey, a secrecy agreement could readily deal with the idea of saying we are keeping the secondary effect, the highly beneficial effect of this drug secret. And that's the agreement that we have, that in order for them to get it, they want to keep the fact that it has a secondary effect completely secret. That's a much more reasonable grounds for the idea of a 10-year exclusive license. As to what it is. It also makes leaking it a much more plausible thing. The reason I'm harping on this is because what we see here is just simply by presenting this as a patent in popular entertainment, they have actually made the issue less plausible and the premise of this element of the show less plausible than if they had said it was a trade secret. But the reason they likely mention patent is because most people don't know what a trade secret is, but they do know what a patent is. So what we see here in conjunction with the entertainment presentation of the law is an issue where they are using the wrong term because it more generally pops to somebody's awareness of the idea that this is intellectual property. But unfortunately, their very choice of the form of intellectual property that they used actually makes the issues that the show has in conjunction with this very implausible to those who actually understand what's going on. And this is a common problem in entertainment. It is a common problem, even in many respects in news reporting, of people not necessarily understanding the interaction of legal rights. This is not unique to IP law, but it is an area where IP law is an area where you see a lot of it because it's so little understood by people who aren't practitioners. And hopefully as listeners of the show, you've gotten a little bit better understanding of these types of things. So it's things, again, where you'll occasionally see in popular press, hey, this, music label artist is suing somebody for trademark infringement, when they're actually suing them for copyright infringement. Two very different forms of IP law. The thing being, and again, where I'm harping on this as to what it is you see these types of issues occur in entertainment. And for the most part, and like this one, is this a write-off issue? Yes, it is. It's really not important to the show, to the premise of the show as to what's going on with this. This is a patent application, or this is a trade secret. It simply matters of the fact that these characters need a reason in order to break into their place of employment and to stop this thing from happening. But the fact that they particularly chose one that unfortunately appears plausible to the standard user but is very wrong is concerning to somebody like me who practices in this area because of the presentation of the law as being wrong. And it's something where, when you look at it in a more general thing, this can be an issue. So examples of things that have been talked about. There's a lot of discussion of the fact that when they started putting Miranda rights being read to criminals in crime TV, it meant criminals understood their Miranda rights better. It's a very interesting sort of phenomenon. It was actually studied. I don't have the studies for in conjunction with it, but I remember learning about it in law school with them talking about that they started putting Miranda rights in criminal shows. People understood their Miranda rights. The point of your Miranda rights is that the case Miranda, which went to the Supreme Court, said the people need to know they have this right. That you have a right to an attorney, that you have a right to remain silent. Those are constitutional rights in the United States. If somebody's trying to pressure you to speak, police are trying to pressure you to speak, you have a right not to. You have a right to tell them nothing until your lawyer arrives. And that's a very fundamental and important right in the United States. And the fact that it's portrayed that way is very fundamental and important in the United States in crime drama, not in true crime, in crime drama, in fictional crime, has actually made the right more understood and has carried out, in some respects, the purpose of Miranda, more so than the idea of actually telling criminals their Miranda rights, because now everybody knows that this is something that they have, that this is a fundamental right that they have under United States law. So presentations of law in popular media and in entertainment are important. And so when we talk about the idea of it being presented wrongly, even in an area like this, which is very subtle and very secondary to the purposes of the show's purpose here. It's a MacGuffin for the idea behind it. We have problems in the idea that, hey, people can get a misunderstanding from that. And as an IP law practitioner and as a patent law practitioner, knowing that people oftentimes misunderstand IP law, seeing it being portrayed with a sort of purposeful misunderstanding, or again, in this case, I wouldn't say it was done maliciously or it was done because they chose the wrong thing on purpose, but it was purposeful in the fact that they did choose the wrong thing but they chose something which works. To get across, what it is, even if that thing may not be technically correct, is concerning. For those of you who happen to be interested in this issue, I'm going to plug another podcast here. One of the ones I like to listen to is Revisionist History, Malcolm Gladwell's podcast as to what it is. I think he explores some absolutely fascinating subjects. He does a 3-part analysis of The Little Mermaid. And with the first part of that, the first episode of that has to do with discussions of the law of the contract that Ariel makes with Ursula. Which is actually an extremely interesting discussion on the presentation and the mistakes of presenting contract law in popular culture. So it's one of those where, again, I think it's worth, talking about that this is not unique to IP. I'm focusing and I'm harping on this being, sort of a piece in one particular show in conjunction with IP law. But it does appear pervasively, and it's a concern in other areas of law. And again, that's what that first episode discusses about. They have a lawyer on discussing, the concerns of this being a presentation, that this not being something that necessarily people, when they're impressionable, kids when they're impressionable, watching The Little Mermaid should understand to be the tenets and the understanding of contract law. So I'm kind of harping on it in conjunction with patent law. And again, treating it as the idea that, Roswell, New Mexico, the premise of it, being a science fiction show about, aliens, obviously having a lot of scientific components and sort of things like that. Should we really be presenting to, potential scientists, bad science, in this case, bad patent law, and bad scientific law? Now, obviously, the show has other elements of bad science in it as well. And one can say, hey, well, it's just simply entertainment. And it is, ultimately in the end. But that's what this episode was about. It was one of the things I wanted to talk about. Definitely thanks, TV Tigger, for, posting up the Twitter about, noting this, and, giving me the spark to turn this into an episode. It is kind of a long episode, as an Edamame episode, as it turned out. I did ramble a little bit there in the middle. Hopefully people are okay with it. But obviously, if you want to talk about this further, feel free to follow up, and I'll turn it back over to Ben and close this out. Talk to you later.
All right, thank you, Kirk. So like I said, we've got 3 more Edamame episodes from Kirk coming. I might try and squeeze one in too. At least 1 rewind episode, maybe 2, and then plus 3 more traditional episodes we've got planned for now. So a lot more coming your way. Stay tuned, and we look forward to talking to you soon. Thanks.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.